I'd like to invite our first speakers onto the stage for the opening session. We have Paul Phillip, the Chief Executive of the SRA, and Anna Bradley, who is the Chair of the SRA. And in this session, we're going to have a chat about some of the big issues in the legal sector and where regulation of legal services is heading. I've got some topics I would like to cover. We're going to be covering things like the strategy, technology, data, some of the big compliance issues we're seeing at the moment and what the implications of that might be. And we've also had some questions in advance, which I'm going to weave in. Now, one thing I would ask is we will have the opportunity to come to questions from you, but if you do have a question, whether you're putting it in on the app or over the mic, please try and keep questions brief. And for this session, we want to try and focus on the big strategic issues. So if you've got a really detailed compliance question, we're more than happy to answer that, but that's probably better done either in the marketplace or in some of the other sessions throughout the day. So, good to see Anna and Paul on the stage. And Anna, I wanted to start with you, and it's actually a question we've had come in advance, so thank you for the person who sent that one in. And they've asked, what do you think are going to be the SRA's key priorities over the next 5 years?
Thanks very much. So that's something that we've been thinking about very hard over the last period, and thanks to over 17,000 people like you actually who've contributed to our thinking, we've now agreed our strategy for the next 3 years, which starts very shortly. So I thought I'd just give you a whistle-stop tour through it, and then maybe we'll pick up some of the detail in other questions. And I know that lots of the sessions will touch on the work that we're doing in each of these areas. But the first thing to say is that we've introduced a sort of statement of ambition, I suppose, what we think we're all about as a regulator, which is driving trust and confidence in legal services. And we think that everything we do underpins that and should underpin it, which is of enormous value, we hope, both to the people who use legal services, but also to the profession who are delivering them. And then there are 4 objectives, and the first is about high professional standards. There's no surprises there. It was the core of our last strategy. It remains the core of this strategy. Some of the bits of work underneath it will be different. And there'll be lots more of that during the course of today, I know. But before I talk about that aspect, perhaps a word about the other 3. So one is about risk-based and proactive regulation, and a central part of this is data. Using the data that we have and that others have better than we have in the past to really make sure that we can focus our resources on the places where things are not going right as opposed to the places where they are. To give you an example, a couple of examples, one is in relation to the work we'll be starting this year on competence, continuing competence, working out where there might be issues about competence. We've done a huge amount of work on that, which we'll perhaps touch on later. And the other is in relation to trying to map, using our data to try and map where services are at present and where they aren't, and mapping that against need for access to justice. So drawing a picture of where the greatest need is, again, using data. So the third area is, again, not a surprise. It was in our last strategy. It's about technology. Perhaps 2 things worth mentioning here. I know a lot of people in the hall are from smaller businesses. We heard from smaller businesses that you need help to make sure you don't get left behind in relation to tech. That will be one of the things that we will be working on. The other is AI. Front of mind for everyone. Don't think any of us have the answers, but AI is something we need to be in touch with. And finally, being an authoritative voice, because, as I've said on this platform before, we aren't the answer to all the problems, but we do have a contribution to make. Again, data, which can be helpful. So I've mentioned the deprivation mapping tool that will help perhaps in a debate about access to justice. EDI, another issue that we can't address on our own. So back to standards, and I'm perhaps, surprisingly not going to just talk about standards for the profession, but actually we think we need to hold ourselves to high standards too. And one of the areas that that we'll be focused on in the next period is some really important improvements in our enforcement activities to try and make sure they are as timely as possible. And I know Paul might touch on that in a bit, but trying to hold ourselves to the same standards that we hold the profession to.
Thank you, Anna. And actually, yes, we did have a question in advance on that particular point around the speed at which we carry out our investigations. And Paul, perhaps I could come to you on that, but perhaps I could broaden the question out as well as to, do you think the types of cases we're seeing are changing? And actually, are the ethical expectations of the profession changing? So what do you think, Paul?
Well, first of all, can I add my personal welcome to Ben's? It's good to see so many people taking the time out just to think a little bit about regulation and about what it means to be a solicitor. So yeah, as Anna's already alluded to, we have a big agenda, and there are some things that we're doing really well and some things that we probably just need to do a bit better on. And I suppose if I reflect on my time at the SRA when I started, our caseload was 99% misappropriation of client funds or stealing client funds. And actually, if you look at the caseload now, it's changed really beyond recognition. There is, unfortunately, still quite a lot of misappropriation of client funds, but you only need to look in the legal press to see the types of things that are popping up in society and therefore echoing in the legal profession, from bullying in the workplace to sexual misconduct to non-disclosure agreements to inappropriate behaviour in litigation. And from a personal perspective, I think you've got to reflect on the core values of what it means to be a solicitor, to act with integrity, to act with independence. Those are fundamental tenets of being an officer of the court, and those are the types of things that we are seeing perhaps not being upheld as much as we would expect to see in the profession. So our caseload has changed radically, and no doubt we'll come on to talk about things like financial sanctions and, importantly, AML. But that means that the way in which we handle those cases has to change too. And in the middle of all this, we've had COVID, and lots of organisations, shall I say, hoofed it during COVID, and we did that as much as anyone else. And therefore, actually, although I'm pretty sure that we're coming to the right outcomes, we're not doing them in as timely fashion as we should. The vast majority of cases that are received are actually concluded within a reasonable period. But if we want to investigate further, then the nature of those investigations become quite complicated. They rely quite often on oral evidence, which is not something that ever really happened in yesteryear. And therefore, they're taking a bit longer than they should. And our board is rightly holding us to account to make sure that we have an action plan in place to remedy that situation as soon as possible, and I'm pleased to see that we're on the case. So the types of things that we've done, well, first of all, we've retrained all of our case handlers. We've written new guidance for all of our case handlers. We've just employed 25 new case officers to deal with the volume. And we're pretty confident that we will get it back on track pretty quickly.
Thank you, Paul. And I wanted to, we've got a couple of questions perhaps about technology, and that's something you touched upon, Anna. And particularly you talked about better use of data. Could you give us an example of what that might mean in practice?
So I mentioned the work that we've just completed on continuing competence. So we have been spending a lot of time and money, actually, over the last period trying to get all of our systems together and all of our data online. The wonderful thing about that is it allows us to then use the data that we have about the complaints that have come into us, not just in the last year, but over an extended period of time, and do some analysis of that to identify where the most complaints are, and what kinds of issues they are about. Importantly, that allows us to then focus our energy on perhaps doing some thematic work in those areas, and thinking about how we can give better guidance to the profession in those areas too. And that's really important because there was a period, so just let's turn the clocks back. There was a period a couple of years ago when the Legal Services Board were talking about a new competence regime, and there was a spoken fear in the profession and else, sort of around the profession, that what that would mean was a reassessment, a regular reassessment of your ability to operate. For us and for you, that would be a very overweighty, in our view, way of handling competence issues. So being able to use the data to focus in on the areas that are a problem, we think that's the right way forward. Happy to say we've persuaded the LSB it's the right way forward, and that will be what we're doing over the next period. Another really important area for the use of data is anti-money laundering, and for very much the same reasons. You know, we've often spoken about an expectation that maybe others have, that we should be inspecting everyone in relation to anti-money laundering. We've always said we should be focused on areas of highest risk, and again, that depends on having the data to really identify it. So these are two really important examples for us as a regulator of how we protect the public, but do it in an efficient and effective way.
And actually, you mentioned anti-money laundering. I thought it might be worth picking up on that because you'll see there's 2 sessions on anti-money laundering today, which reflects the importance of that. But Paul, did you want to reflect on where we are on anti-money laundering? I think there's something we're publishing today on that very issue.
Yeah, I mean, if there are any regulatory geeks in the audience, you'll know that the terms proactive and risk-based have been around in regulation for a long time, and Anna's absolutely right. As well as being reactive and dealing with complaints about solicitors and authorising solicitors to practice and that type of thing, we're under, I think, a very clear obligation to use our resources wisely and in a proactive way, trying to identify risks in the marketplace. And that type of modus operandi is what really we're trying to do in our AML work. And in terms of looking at where the risks are greatest, we do things like thematic reviews or thematic inspections. And coming out of that type of work, we're getting quite worrying messages about compliance with AML regulations. Now, I'm always reminded that when I ask solicitors what's the number one thing you would rather we didn't do, they say AML regulations. And of course, AML is nothing really, it's not of our genesis or our origin, it's legislation. And the government's clearly of the view, and I have to say, honestly, in relation to a minority of solicitors, rightly of the view that solicitors and accountants and estate agents are often seen as enablers of laundering money. And because of that, they've been fairly proactive in making sure that actually they come down hard on that. And we're very much part of that as a frontline supervisor for AML. So today we're publishing a thematic review, we're publishing a warning notice on the back of that in relation to some of the compliance issues we have seen in relation to risk assessments in AML compliance generally. And we're also basically making the point that actually further compliance needs to happen in AML. And we can see no other way forward but to consult on changing our automatic fining arrangements so that where we find non-compliance with AML regulations in future, there will be automatic fines in order to bring people into compliance. AML is not a victimless crime. There is human misery behind all of this. And I honestly believe the vast majority of solicitors are not doing it deliberately. You're busy people, and it's another bit of bureaucracy that you have to deal with, but it's a really important bit of bureaucracy, and therefore we will be coming down harder where we find non-compliance with AML regulations in future.
Thank you, Paul. And we were on the theme of technology, and one of the big things that's happened or exploded in the last year since you were last on the stage is sort of AI and what will be the impact of AI on the profession. I suppose the question is, are we on the cusp of, robot lawyers, or are our human lawyers in the audience safe? Paul, do you want to kick off on that?
I think that's a question you need to put someone about 30 years younger than me. but yeah, I mean, I have no inside track on AI. What I do know as running the regulator is I see the inside of lots of law firms, and I see law firms who have the resource and who see the opportunity that AI presents, looking at it and playing with it and trying to understand it. There are obvious issues associated with it, particularly in the legal profession, around about confidentiality, data protection, that type of thing. But with appropriate safeguards, I can only repeat what people who seem to know a lot more about it than I say, which is, A, it's pretty scary, and the robots might be coming, but we don't know when, and we don't really know what that means. But B, it's also pretty exciting, and it has the ability to really create massive efficiencies in law firms and to provide massive opportunities for things like access to justice. And I'm sure that's true, but I think a little bit of development is needed before we would actually see the proper utility of those types of things. So I'm not too sure if everyone in the room is safe. Certainly when I speak to the bigger firms, their manpower planning is looking like reduced numbers of solicitors going forward. There's no doubt about that. Whether or not they're right, you know, history will tell us. But from our perspective, what we are trying to do is to keep up with the discussion, keep up with the debate, understand what's happening in early adopters of AI, and try and guard against some of the pitfalls for lawyers going forward.
And hopefully in the short to medium term, there's a chance to use AI to deal with those more administrative tasks to free up the time for lawyers to use their expertise and what they do really well and what they're trained for. Anna, perhaps I'll come to you and broaden that question out in terms of what role does innovation and technology have for unlocking access to justice? Is that why we're interested in it?
Well, certainly why we're interested in it, but that's not the only reason that people should be interested in it. I mean, it has the potential to create huge efficiency benefits in firms, and I think firms should be interested in it for that reason alone. And hopefully that passes through to clients, which should have an impact on access to justice, but not perhaps a dramatic one. I think the reason we're interested in it does relate to access to justice, and it's about the potential to use tech to give people access to services which they wouldn't otherwise expect to have. Let's remember that many people don't approach legal services because they're quite scared, or they actually don't know. They're scared about the cost. They think professional services are not for them, or they actually haven't identified that they've got a legal issue. And we think, and I think many others agree, that using tech as a front door will be a way to help lots of people to identify the fact that A, they have a legal issue, and B, what kind of legal issue it is and how much they can do about it themselves. And I don't think the fact that some people, of course, are not as digitally able and don't have the tech available to them, but that doesn't mean they can't benefit from these developments, because third sector agencies such as Citizen Advice and all the legal service advice services can act as an intermediary and can also benefit from the use of these kind of entrance level tech developments. And actually, tech can also help us go another step further, which is to unbundle legal services so that people can do some of those things for themselves at the front end, filling in some, often very complex forms, particularly around family law, for instance. People can use it in circumstances where they don't feel able to talk directly to anyone. We've trialled developed using government funds, a project to support those subject to domestic violence, so that they can use this in their homes to begin to create the kind of diary they need of what's been happening to them and why. So these are new sorts of services, and that's another benefit, that we can offer people new services. It's not going to be the whole answer, but it's a very important addition to the toolkit, and we want to do what we can to ensure that it gets used in some beneficial ways.
Thank you, Anna. And the innovation team from the SRA is here out in the marketplace. So if you want to know what we can practically do to help support you in that area, please speak to them. There's also some really interesting external speakers on the innovation session later on, including someone who's been doing unbundling, I think, for about a decade and can talk through how that works. There's some questions coming on the app, and I'm going to come to them just in a moment, but there was a couple of sort of, I suppose, meaty compliance issues I wanted to just explore. We've seen a lot of coverage in the legal press and the national media in the last few months with attention. The first of those was around attention around action we took against the immigration solicitors. And I suppose my question is there a big problem there? And also, does it worry you some of the sort of political or overly politicised language that has sort of attached itself to those cases? Anna, did you want to start on that and maybe come to Paul?
Well, yeah, just to deal with the political aspects, I suppose. I mean, I have to say I'm immensely proud as the chair, and I can say this because I don't have any active part in it, but I'm immensely proud of the fact that the SRA was able to act as swiftly as they did in relation to the mail investigations. I think, you know, that's exactly what we need to do to protect the public, and then we need to take the follow-on actions to look at the extent to which these are broader issues or not, and or not maybe the right outcome. We just don't know. So, you know, acting swiftly when evidence is put in front of us, that's what a regulator should do. And we shouldn't be scared by the fact that it's happening in a very highly politicised environment, and there was no question that it was. We have to sort of work then to ensure that we don't get drawn into those political debates in an inappropriate way. And I think we thought very hard about that. We have sought to do that in this particular case. I think we found the right line. Always happy to hear if people felt we've done otherwise, but really important to us as a regulator that we are separate from the political process and those kind of political issues. But we shouldn't be scared just because it's a politicised issue. Paul?
We did our job, so we were faced with evidence that seemed fairly strong that the individuals involved were doing things that I think, if it were true, I think, and I would hope that everyone in the room would agree, it should question whether or not they should continue to be solicitors. Now, obviously, that's in a disciplinary process. It may well, probably will end up at our solicitors' disciplinary tribunal, and we'll see what happens there. But if it were true, solicitors shouldn't be doing that thing. They go straight back to the whole idea of acting with integrity and acting independently of your client. So we did the right thing. Unfortunately, as Anna says, it was against a politicised backcloth, and the question is raised, and the allegation that was put is that this is really widespread and it's everywhere in immigration. Well, we have no evidence that it's everywhere in immigration, and I have no doubt that, as in every other area of law, immigration practitioners are out there doing a really good job under increasingly difficult circumstances. But we are obliged to look further to see whether or not there is further evidence of that, and to that end we've done two things. We've published a warning notice which I suppose makes explicit that which is implicit, which is you shouldn't be doing this type of thing at all. And two, we will be following up a sector inspection regime to look at a number of the major players in immigration to make sure there's no evidence of this. And everybody wholly appreciates that the types of things that looks like were found in the Daily Mail sting are wholly unacceptable.
Thank you, Paul. Let's move to some of the questions we're getting in on through the app. And firstly, we've had quite a few questions, so thank you to Brian and Richard and others for sending questions in on this theme about Axiom. And again, that's something that's hit the headlines recently about a very large firm that we've had to close down and intervene into. But actually, there's been a number of firms where we've had to intervene into in the last year. Now, Paul, you're not going to be able to go into the details of a live investigation, but it does raise questions, I suppose, around the broader sort of protections, and also is there a growing trend of issues with us having to go in and close down firms?
Yeah, this is a big deal, I think, and our board had a private discussion about a number of things yesterday, but, you know, client protection or compensation arrangements were definitely at the core of it. We've had the three largest interventions in the history of not just the SRA but the Law Society, in the shape of Kingley, Metamorph and now Axiom. These interventions put any other interventions really into insignificance, nearly. over the last few years, interventions into law firms have been going down, and we've seen that as a really positive thing. And as a consequence, the amount of money that we have in the compensation fund and the amount that we collect from the profession every year has either gone down or stayed static. But on the back of the 3 interventions that I've mentioned, we are beginning to think very carefully about compensation arrangements and client protection arrangements and the viability of the present regime going forward. Because there's no doubt in my mind, as a consequence of the 3 interventions that we've touched upon, we're thinking about things like, is this a pattern? Is it going to happen again? All 3 of the firms had grown by acquisition, so-called accumulator firms. And therefore, there is a move in the marketplace towards people buying up little businesses, and we've got to make sure 2 things: that client money is absolutely safe, and that the firms that are doing this have the management capability to deliver high standards of service as they're obliged to under the Legal Services Act. But from our perspective in running the fund, the financial implications of paying out vast amounts of lost client funds means that there will be implications for the cost of client protection going forward, for the compensation fund fees in the next few years, and for the shape and level of compensation that we think the profession should be providing to clients. So what we talked about at our board is perhaps the need for a fairly fundamental policy review of how we do business here to make sure that it's proportionate from an affordability perspective, from your perspective, and also that it ensures that it, as much as possible, maintains some trust and confidence, which is the bedrock on which you do business.
Thank you. We've had a few questions come in around sort of CILEX and potential redelegation of CILEX lawyers to the SRA. I'll pick up this one from Rebecca, who's asked about CILEX, and do you see the potential of this moving towards, or is this a move towards a single regulator? Anna, perhaps I'll start you on that question, and then we'll go to Paul.
I mean, I don't think there's any chance of there being a single regulator or a move to single regulator without legislation, and I don't see any ambition in Parliament from either party for moving to that legislation at this point. There's too many other issues on everyone's minds, whichever the colour of the government. So, and you would need that legislation to move to a single regulator. I mean, I think this is a much more pragmatic and practical proposal, which was explicitly made by CILEX, the representative body, who came to us and asked if we'd be prepared to put a proposal to them because they saw some issues with the arrangement that they had previously delegated to. So this is very practical. It's small. I don't have a queue of people knocking at my door saying, "Me too. Yeah, we'd like you to take us over as well." So I think the short answer is no. I don't. This is not a development towards a single regulator, which isn't to say that there might not be a political will at some point to move in that direction. And certainly the LSB has made no bones about the fact that it thinks that's the right way forward. But we're not headed there right now.
Paul.
I agree with Anna, and I don't think that the politics of the day, that this issue is anywhere near the top of the agenda. So no, I don't think that's the case. I think in relation to CILEX, as Anna says, CILEX regulation is a relatively small organisation. It's regulating about 20,000 individuals, and only about 7,000 of those have autonomous legal rights or to practice, as it were. The fact is, it's tiny. It pales into insignificance in terms of our size and economies of scale. The reality is that 75% of all practicing CILEX members work within SRA authorised firms, so they work for people like yourselves. So it's not a big deal. There's lots of synergy. It's in many ways a tidying up exercise, and we didn't seek it, but actually when CILEX suggested that we do it, we can see good reasons why we should. But no, it's not the slippery slope, in my opinion.
Thank you, Paul. And there isn't a session specifically on that potential switch and consultation today, but actually there was a webinar on YouTube we ran a couple of weeks ago. So if you're really interested on that and we're on a respondent consultation, do have a look at that. that the app is obviously where people want to be. So I'm going to go to another question on the app, which is, this person's asked, is there any update on your work looking at potential disproportionality of minority ethnic groups in your enforcement processes?
Well, essentially, as I think we've already said publicly, we're in the business of having commissioned two major pieces of research, one into why it is that people from minority groups don't do as well in licensing examinations, in particular in relation to the LPC and now the SQE, as white people do. I think it's Black British as a category of those who self-identify as Black British do woefully bad compared to other characteristics. The second piece of research is why is it that when our intakes of complaints about solicitors into our disciplinary work are overly represented from people from Black minority Asian communities, and why is it at the front assessment where we decide whether or not we're going to investigate or not, we make that percentage a little bit worse. Now the good news is that once we've investigated the concerns, actually there's no disproportionality in the process. But we've got these two major pieces of research that will be done by credible universities or groups of universities, and they're going to report probably in the spring, probably April, May time next year. I'd be gobsmacked if there were categorical reasons, they come out and say it's because of X or Y, but it will help the debate. Our view was, and our board felt, that these were statistical anomalies that had to be explored, because it cannot be right that people from particular groups in society, particular demographics, are either overrepresented in our disciplinary intakes or don't do as well in licensing examination. There has to be a reason for that, and that's where we are right now. So that's the type of work that we're doing, and I'm sure the debate will continue on that.
If I could, Ben, just to say that it's our hypothesis, and this is certainly the hypothesis that the first round of reporting from these studies is supporting, is that actually these issues are much wider societal issues, not just affecting us, but affecting society as a whole, but all the assessment approaches to assessment, etc. And while there will, I hope, be some things that we can do as a regulator that follow from the final reports, I suspect that the bigger conversation will be the one that we need to have with everyone else about what society needs to do. And that's a very good example of what I talked about at the beginning in terms of the fourth of our objectives being an authoritative voice. So hopefully this research will be of benefit to a much wider conversation, not just actually in the legal sector, but broader than that too. That's what we want to bring to the table, but we will look to many other people actually to find some of the solutions, I suspect.
Thank you. I'm going to have a second bite of the cherry of going out to the audience. Yes, I can see a hand has gone up in the middle row just there. If one of the microphones will just get to you, I think it's a woman in a sort of grey whitish dress. If you could hold the paddle up, it's number 1 for the microphone. Thank you, and well done for asking the first question.
Thanks, Ben. So Anna was talking about the strategic objectives and talking about access to justice. And I wondered whether, when we speak about being an authoritative voice, and particularly the situation with legal aid, we've seen that being diminished over the years, which is the real struggle in terms of where does the problem sit. If we're not funding solicitors to do certain work, that creates gaps. We're losing young lawyers that don't want to qualify in those areas. So I just wondered if you could touch upon whether, is that something that ties in again with the authoritative voice, and whether it's more a case of discussions with government?
Can I come to you first on that, Anna?
Yeah, absolutely. So that's a very good example of why we think we don't have all the answers to access to justice. And you point to government quite rightly, but actually the people who have appropriately taken it upon themselves to influence heavily on behalf of the profession in relation to legal aid are the Law Society. And we see this as an area where we and the Law Society should have absolutely common cause and should be working together so that we are playing our part, but so are they. And I think their part is very importantly lobbying for policy change in relation to the way legal aid is delivered. So in partnership, but not necessarily us speaking out on every aspect of what needs to be done in relation to access to justice, I would say.
Paul, did you want to add anything on that?
No, it's a bit of a slippery fish. It's easy to say, well, the reason why there's not access to justice is there's insufficient public funding. And actually, my personal view is there is insufficient public funding, but that's a political decision and not one for us. And the Law Society is there not just to represent the profession, but to represent a number of wider issues associated with justice and society. And they've done, a terrific job of making those points. We don't disagree with them, but we think that they should take the lead on it. I think the slippier issues are issues which we've touched on when we talked about technology and stuff like that, whereas is the only answer to access to justice to give solicitors more money to represent clients? Are there other people that could do it? And we talk about this mythical, unregulated sector, but there's no doubt there are lots of people, because you know that the term lawyer is not a protected title, so there are lots of people calling themselves lawyers who may or may not have had some sort of training and who are providing some sort of service to society. And if you look at the tech companies that have the obvious opportunity to come into the marketplace and provide technological solutions, or to go back to the dreaded AI, to try and allow more self-help in the marketplace, I suspect what we'll see going forward is a sort of multi-headed type of approach to access to justice. Whether or not it's as good as it has been in the past, I think is highly questionable. But I can see that if I were in government, I'd be looking at a number of different ways in which you might approach access to justice. And the idea that, well, access to justice means there needs to be more legal aid, it's quite a difficult one for solicitors to argue, because you are conflicted. Yes, I fully agree with you, and I fully acknowledge that you're probably raising this for proper egalitarian reasons, but it's also your income at the end of the day, which is why I think the Law Society has a bit of a problem presenting that, because it looks a bit too self-interested.
Thank you, Paul. We've probably got time for one or two more questions. Any other volunteer now? Like a buffet, usually once one person's going to, you get more. So, well, we've had another question on the app, if I can't see one. And there's a few questions on anti-money laundering. I'm going to hold off those just because we've got detailed sessions on those. But someone has asked, what are you doing about high insurance premiums for firms? We know in particular for small firms, they're a really big burden.
I think I got asked this one last year, and I'm sorry, I'm going to say the same thing, which is that as a regulator, our role is to look at whether or not we feel the market is failing. But if I can broaden the question out for a second, because I think there is an issue here. PII is going up. It's a pretty hard market at the moment. AML levies are on the horizon. Compensation fees look like they're going to be going up. Let's be just frank about it. In other words, the overheads and the costs of running law firms are going to get more onerous going forward. From our point of view, there's not much we can do about that type of thing. The PI market is what it is, and you know, if you've been around a while, it's soft at some point and it's hard at others. And speaking as someone who's just tried to reinsure their car recently, I was absolutely gobsmacked that my premium's gone up 300%, despite the fact that my personal circumstances haven't changed at all over the last year. So I think all of us in society are facing that type of thing. But I go back to the point that I wanted to make in relation to the compensation fund, which is perhaps a more general issue, which is you've got to look at the regulatory regime, you've got to look at the burdens on solicitors and ask yourself, is the balance right between public protection and the cost to the profession? And that's certainly an agenda that we'll be taking up with our board in the months and years ahead.
Thank you, Paul and Anna. I see that we're just a couple of minutes from the end of the session, so I wanted to give you both a chance just for any final takeaways from your side. Anna first.
Well, I suppose I would say, so no sooner was the ink on our strategy dry than we faced the intervention into Axiom, and that is just to make the point that that we can't stand still, and we constantly need to think about whether we've got the right things that we're focused on, or whether we need to turn our attention in a different direction. As Paul said, we had quite a conversation about that at the board yesterday. And I think you would expect us to do that. I think the sector needs to do it too as a whole. I think we always need to have our eye on not just what's in front, sort of on our plate, but what's in front of us. And in that context, I think things like AI are the sort of thing that we need to engage with, even as we've both said, we don't know the answers. So being alert and on one eye always on the future, I think is absolutely central for us. That would be my message, I think.
Paul?
I think the only thing I haven't picked up on this morning that I think is really quite relevant to the discussion today is the idea of increased fining powers. And I could have raised it under immigration, but it's not really about immigration at all. It's about the idea that we have been for about 10 years now asking for much greater regulatory tools to ensure deterrence of aberrant behaviour in the profession. And we've just got our findings powers increased from £2,000 to £25,000, but that was really more an efficacy issue. It's about trying to make the system work better. What we're actually asking for, and what it looks like we're going to get in AML, is unlimited fining powers so that we can deliver fines to deter people from engaging in the type of behaviour that shouldn't be happening in the marketplace. The LSB are presently running a process to consider that. And actually, from our point of view, what I wanted to say is that solicitors who are out there doing a good job, and I include most of you in there, have nothing to worry in relation to that. However, where we find people that are doing the types of things that you shouldn't be doing, I truly believe that A, they should face personal action before the Solicitors Disciplinary Tribunal, but also the partners in that firm must take some sort of responsibility for self-regulation. I was saying to Ben beforehand, I used to regulate doctors, and if your mum's going in to get a hip replacement and you know a friend is a doctor and you say, who should do this type of thing? They'll say, oh, Mr. Snooks and Mrs. Boggs are really good, but don't go to Mrs. Smith. And that type of information, that type of intelligence is what regulators need. Now, the types of people who know who the bad lawyers are, and I fully appreciate they're a tiny minority of you, are you. And I would like to try and instill with some degree of proper self-regulation within the firm, and I think we will try and use fines as a way of doing that. If individuals do things wrong, they should be sent to the tribunal. If firms do things wrong, they may well be sent to the tribunal, but they may well also face very material fines going forward. And in the next few months, if the Economic Crime Bill becomes law, I fully expect that we will get unlimited fining for AML, and we will have to use that. So you will see very significant fines coming forward for AML in the short term, and if I have my way, for all sorts of misdemeanours going forward.